Okay, we're going to call the Board of Appeals meeting to order at 5:32 p.m. I will do the roll call. Please say present when I say your name. I do want to note that Adam Burns has been excused. Cara Espera. Michael Polson,
Present.
Don Tutenhoff,
Here.
David Keating, and Chair Wendy Smith.
Present.
I do want to state that this meeting has been properly noticed and posted according to law.
Okay, good evening. Tonight we have one item for consideration, request for variance, but before then, I'd like to start with item number 4 on our agenda, which is consideration of meeting minutes dated August 16th, 2022. I'd like to ask the board if there are any recommended revisions or modifications to the proposed minutes as included in the agenda.
I'm done.
Hearing none. Can we call a vote to approve these minutes? Do I have a motion to approve?
So move.
Thank you. And then can we call that to a vote?
Michael Polson,
Aye.
David Keating. Okay. John Tutenhoff,
Aye.
Cara Espera,
Aye.
Wendy Smith.
Aye.
Motion carried 4-1.
Okay, great. Moving forward to item number 5 on our agenda, Village Attorney Nathan Bayer will discuss the standards by which the Board of Appeals must abide when considering our request for variance tonight.
Thank you very much. As we begin, before we jump into discussion of variances and this specific application, there are a couple of preliminary jurisdictional matters that I wanted to just point out, and then I had a couple of questions. First of all, I just wanted to acknowledge in terms of the applicant tonight, I will say that this is a sort of a unique situation and one in my many years of working with municipalities. I haven't seen previously a building permit that was issued in what was admittedly in error. So as we work through that, as I read the report from the municipality and the inspector's office, it indicated that there were 3 issues. One relates to the error that was made. There was a building permit issued on a chain link fence that was placed in a front yard, which is otherwise prohibited by the code. And then there was a second issue of the height of the fence, regardless of whether it was chain link or any other type of materials, that it exceeded the maximum allowable height. And then the third one was that it also encroaches into the public right-of-way as well. So I wanted to focus on the last one first and just point out that when there is an item that is placed in the public right-of-way, or there's a request to place an item within the public right-of-way, that the special privilege approvals for that go to their process through the clerk's office, and they go to the village board. So I just wanted everybody to be on the same page that the Board of Appeals at this point doesn't have any jurisdiction over the issue of whether or not the fence encroaches into the public right of way, and the Board of Appeals doesn't have any jurisdiction to grant a special privilege, which is different than a variance, to do that. So I didn't want the cart to be before the proverbial horse. I mean, I guess we could theoretically address the others, but I just wanted to make sure that everyone was on the same page with that. And I guess the question that I would have for the inspector is the issuance of the building permit in error, does that just relate to the chain link fence, or did it also erroneously approve the height and the area within the right of way?
Attorney Inspector Barris, can you raise your right hand? Do you attest that do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. So it is in relation to the material type only, the chain link. So I personally did not approve the building permit application. However, I do know that we have that material with us within our packet. And so they indicated a 4-foot tall fence. So with respect to height, it was indicated at 4 feet. And with respect to the location in the public right of way, the information that was provided in the application was not to scale. So I'll say that it couldn't have been necessarily determined through the application that it was going to be in the public right of way. I'd say that if you were going to use kind of a general scale that they provided, it looks like it would not have been, that it would have been back at least 4 feet, because the sidewalk is 5 feet wide. So again, but it's not to scale. So again, special privilege is more easily attainable, but provided the location that it is, we wouldn't have expected it to be in the right.
Okay. So I just wanted to make sure that the applicants or the appellants here tonight understood what was properly before the Board of Appeals and what would still be subject to review and a request made to the actual village board. So the special privilege approval for the being in the right of way is not something that will be addressed this evening, or in my opinion, shouldn't be. And then working backwards, the height of the fence, I think, is clearly within the purview of the Board of Appeals. And generally, just to work from the general to the specific, so the applicants can understand generally the powers of the Board of Appeals. A lot of the items that come under the purview of the Board of Appeals is something that is otherwise allowed, but placed in a different area or beyond or invades the public right of way or something. And a lot of times, just as an example, sometimes we have lots that are not compliant with the code that was passed, or the lot was created before the creation of the code. And they're a non-conforming lot, so they're not large as they should be to begin with. And somebody wants to redo a garage, and they want to invade, 6 inches or a foot into the public right of way to squeeze the garage in. That's generally under the purview of the Board of Appeals. So another example of something that's under the purview is, for example, someone will want to place an accessory structure like an HVAC unit within a certain feet of their home and within a certain feet of the lot line, and it says you can't do that. Again, if there's a non-conforming lot, the Board of Appeals has the ability to soften that code provision in that requirement and say you can move it over here, not over there, and that kind of thing. So the height of the fence is in my opinion something that is 100% under the purview of the Board of Appeals. Because a fence in general is allowed within the front yard. If there's a particular issue that would make it impractical to meet the height because of maybe there's a big slope or a pitch or something to the yard, and based upon where you can place it, that's impractical. In my opinion, that the 4 inches over, I think, is under the purview. Here's where it gets a little murky, and here's where I think that the Board of Appeals has to look at this and evaluate on its own the jurisdictional question. The code as it's written says that chain link fences are not allowed in the front yard. And if we look at the powers and duties of the Board of Appeals under 535-55, it talks about variances. And it says that this body has the ability to hear and grant appeals for variances that are not contrary to the public interest, where, owing to special conditions, a literal enforcement would result in practical difficulty, unnecessary hardship, so that the spirit and purpose of the chapter is observed and public safety, welfare, and justice secured. I think the key language is the last sentence here: use variances shall not be granted. So the question is whether we're talking about the placement of an item that is otherwise allowed by the code. I think that that is clearly under the purview. Versus in this particular case, the code says that chain link fences are not allowed in the front yard. The use variances are not clearly defined in the code, but in my opinion, that in this particular instance, this could be considered a use variance as opposed to a softening of the provisions as to where to place a particular item. It's just completely banned by the code in the front yard. Now, the last element that I looked at, and I did some research on this, and I pulled up some cases and looked at the annotations under some statutes. I think just as, you know, all of us in this room are you know, human beings, we would not want to be in a situation where you know, we certainly understand and are, you know, we have empathy for the fact that we have a building permit that was issued in error, admittedly in error by one of the inspectors. And I wanted to look to determine whether or not there was anything specifically that the courts had said about that. And the courts were pretty clear that a permit that was issued in derogation of the code is not otherwise enforceable and cannot otherwise be is not otherwise upheld on challenge. And in the converse situation of what we have here is when in other situations where permits were issued in error, other neighboring property owners have been able to challenge and stop the issuance of the permit or reverse the issuance of a permit. So I was hoping to find something different there, frankly, just as, you know, a sympathetic individual to what has happened here. But the Wisconsin courts have generally spoken and said, unfortunately, that, you know, if a permit is issued in error, it doesn't unfortunately grant an automatic right of the individual that holds the permit issued in error to continue through and build whatever the permit was granted on. And I know that that's unfortunate and it's not ideal, but that is what the courts have said. So in my opinion, you know, there are three items, or there are three reasons that this particular final inspection was not approved. And that is because it was placed within the public right of way. And again, my opinion is that this body does not have jurisdiction over that. And that is something that will have to be addressed eventually by the board of the full board. I do believe that because in general, you know, there's in concept, fences are allowable, just not this type of fence. I think that generally the height of a fence is something that would normally be within the jurisdiction of the Board of Appeals. But I think the problem we run into is, I think that the use of the front yard by placement of a chain link fence, which is otherwise strictly prohibited, I think takes us out of the realm of where we're not really granting a variance by saying you can place it here, or you can take something that is otherwise allowed and move it closer to the lot line, or you don't have to meet the setback requirements, or you can exceed, you know, the green space requirements. That I think the problem that we run into is, you know, that this is more like a use variance because of the chain link fence being completely barred in the front yard. And then I think it raises the question as to, you know, whether or not the Board of Appeals can do that. Now, the Board of Appeals can absolutely disagree with me. It is up to the body, but my opinion is that it's a close call, but evaluating those terms as they're used in the code is that I think this looks more like a use variance that would be outside the jurisdiction of the Board of Appeals. But if the body feels that because fences are generally allowed, just not this type of fence, and views it as a proper variance, it could, you know, that's up to the body upon discussion and debate. Then it's up to the body as to whether or not they would want to grant a variance. So this is a very difficult and complicated case. And again, I think, it certainly put the applicants or the appellants in a difficult position because of the issuance of the permit, if you will, that was issued in error. But unfortunately, that's the hand we've been dealt tonight. So my advice would be to discuss whether or not the body feels that the chain link fence, the prohibition on a chain link fence is absolute, such that this would be a use variance that would not be within the purview of the body, or alternatively, because fences are generally allowed, just not this type of fence in the front yard, that it would be a proper variance, a proper consideration of the variance by the body, then I think it should discuss and take a vote as to whether to grant the variance for the chain link fence in the front yard. And then if it does so, then the height issue becomes a secondary consideration that the body should consider. And then lastly, my advice would be that it not consider the setback issue with respect to the right of way, because my opinion is that would be under the purview of the village board.
Thank you. Do members of the board have questions for Attorney Beer at this time?
No question.
Okay. Is there a statutory definition for use variance?
No, I looked. That's part of the problem. And again, I can see this, I can see a discussion on this and a reasonable decision to go either way on this, because if you look, the one thing that I did is I looked at the conditional use section of 535 of the code. And there are clearly there are uses that are discussed that are generally home occupations and things like that. So in that sense, it's different. But I also looked at some league opinions and some other authorities that talked about the general jurisdiction of Board of Appeals in respect to review of zoning. And all of those talked about generally, that relaxing the regulations that would otherwise apply. In other words, somebody is asking for, just to use the example I used earlier, we'd like to place an accessory structure, which is an HVAC system. And our code says it's got to be at least X amount of feet from the house, but it's also got to be X amount of feet from the lot line as not to disturb the neighbors. And they say, well, that's physically impossible because we have a non-conforming lot. So at least in that situation, which is a good example, is you have something that's otherwise allowed. So the Board of Appeals is saying, we're going to relax the code and allow you to place it over here instead of over here because it's impossible with a lot. So that seems to be different than saying, well, we're going to grant you the ability to put a cyclone fence in when that's otherwise prohibited by the code. But I can also see a reasonable interpretation saying, well, the cyclone fence isn't allowed in the front yard, but there are other fences that are allowed in the front yard with different materials. So we're going to view the code as saying that in general, there are fences that are allowed in the front yard, and we think it's within our purview to grant a variance on the materials. So I can see it. I can see a reasonable argument being made either way there. And I wish I could have found a definitive answer in one of the league opinions that I dug through this afternoon or a specific court case. Unfortunately, I wasn't able to. So I thought that out of deference to the applicants and the body, which can make, I didn't want to make that decision on behalf of the body, as you are all experienced in handling these matters over the, and you've been involved in these meetings over time. I thought it would exceed my purview as the attorney to give you a definitive answer when I couldn't seem to find one either in the code or in the reported decision. So I wanted to leave it up to the body instead of telling you what to do.
So if we determine that this is not a request for a use variance, we proceed with our standard for review for a variance, and we disregard the fact that the permit was issued in error. Is that correct?
Yes, I believe that is exactly 100% correct.
Any other questions from the board at this time? Okay. All right. Thank you. So moving on in our, thank you. People slamming doors out there. Item number 6 in our noticed agenda, request for variance of Village Code 225/8B to sub 7 to place a 4-foot high chain link fence in the front yard at residential property 4040 North Farwell Avenue. We will begin consideration of this matter, beginning with a statement from Inspector Burris.
So to reiterate, we know why we're here appealing the notice of correction. And on their application, again, requesting a variance to maintain the installation of the chain link fence in the front yard. Attorney Bayer has gone over the issues at hand. And then I will just say that, so Inspector Tim Kep approved the building permit application on 8/9/2022 and failed to recognize that the proposed fence material was chain link. It is an absolutely unfortunate oversight, but it is our opinion that the issuance of the permit does not provide an exception to the code. Within our packet, we have the building permit application and plan, the notice of correction that was generated upon final inspection, and then the Board of Appeals application and the material that the applicant has.
And so just to reiterate, the elements that are currently in violation of the code relate to material, the placement within the encroachment into the front right of way, and the overall height of the fence?
Correct.
Okay. I'll open this up to questions from the board for Inspector Burris. Hearing none. And to verify, the height of the fence as it is just a number of inches above 4 feet.
Yeah, 4 feet, 4 inches, yes.
Okay, thank you. At this time, I'd like to ask for if a representative from the owners of the property at 4040 Farwell would like to come to the podium here. See the lectern with the microphone. And please, if you could try to speak into the microphone so that we can all hear you. And I would appreciate your name.
William
introduce-
Ross. I'm representing Mrs. A. Fletcher, or A. Jacobs, owner.
And would you like to provide a statement to us?
Well, I listened to the presentation by the attorney department. Very, very clear that the 29-inch encroachment right of way is not under. We will apply for the village board for that with special exception. I think the real important thing is looking at the picture that we provided of the fence itself. The code makes no distinction between raw steel, chain link, vinyl coated chain link, which was installed. If you look at alternatives, there really are none, or less intrusive, less visible. 4 inches is an unfortunate mistake, not really material. I think that covers the point.
I'd like to open it up to the board to ask questions.
No,
It is hard to see by this picture, but when it was first proposed and the fence was being built, was there? I mean, where did we come off by that 4 inches?
Prior to the installation of the fence, the property owner put 4x4s to guide cars backing in, get a warning before they ran off the driveway. And when the fence was installed, the fence people, erroneous, of course, thought 4.4 was essentially but the material, the 4-foot material on top of the 4-inch boards. That's a designer, it was an installation error, have to.
Okay.
We don't think it really is substantial impact on the appeal.
Is there anything unique about this property that requires the fence to be made out of chain link as opposed to any other
No,
material?
just that it was proposed and accepted. It could have been, if the mistake had been caught at the application process, we would have proposed. a different
Mr. Ross, I'm sorry. I'm sorry, I forgot to swear you in. So can you raise your right hand, please? And do you, okay. And do you affirm that the testimony that you gave is the truth, the whole truth, and nothing but the truth? So help you God? Thank you.
Do you have any other statement for us?
Sorry.
Do you have any other additional information or statement that you'd like to provide to the board at this time?
Well, we have pictures of examples around within a block or two of chain link, of raw chain link. In front yards, back yards, things of that kind, but it's all in your.
Yes, we do have those pictures. Thank you. Any other questions at this time? Oh, Nathan, can you go ahead?
I just wanted to make sure because out of fairness to the applicant or the appellant, sometimes people aren't quite sure what they're checking the box, be it variance or challenge to interpretation of to allow. And I thought I may have heard some argument there about whether or not this particular code provision applies to this style of fence. And I just wanted to make sure if we didn't miss that in case that was
Oh,
the
I
argument.
understand that the chain link doesn't differentiate between the old industrial chain link. Final coated. My mind, is totally. But it's not recognized.
Oh, I just, in case that was being advanced, I just wanted to make sure we understood the argument you.
If there are no other questions, you may sit down.
Thank you.
At this time, I'd like to ask for any other testimony from interested parties that might like to give a statement. Please come to the podium and introduce yourself, and the clerk will swear you in.
My name is Chris Callahan, and I live at 4036 Farwell. So this fence, although it's not.
One moment, two things.
Okay.
Can you raise your right hand so I can swear you in? Okay. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God? And can you spell your last name, please?
C-O-L-E-E-I.
Thank you. Go ahead, I'm sorry.
Okay, so I think it's horribly ugly. I don't think it belongs in a front yard in Shorewood neighborhood. I know that there has been problems with chain link in the past, that the owner of the house is very aware of them. Because years ago, she put a chain link fence on the other side of her. And people were very upset, and especially the people who live there, who then moved out. So then they passed a rule saying you can't do that. And she did it anyway. And I think that the code is really clear. I mean, I looked at it online, it jumped out at me in bold print that you can't do this. So, you know, she ignored looking at the code. And I don't think that that's okay. And I don't think she needs one. If she wants one, I have no objection to a regular one that looks okay. That's fine. But not this.
Thank you. And I'm sorry, can you reiterate your address, please?
Address?
Yes, ma'am.
4030.
Thank you.
Any questions for this?
Did you say that prohibition on in the earlier she had And then after. Ed,
After she did that, they changed the rule.
they changed 2258. Are you talking, they changed the regulation? That to say that Jane- So. So.
Was
yeah,
allowed to have the first change because it was a rule against.
okay,
So then they made a rule against. it.
and that's the
It was
rule at
very clear in
issue.
the code.
Okay,
And she knows how people feel about it.
Are there any questions at this time? Thank you for your statement. You can sit down. Are there any other individuals that would like to make a statement this time? Please come up to the podium, please, and introduce yourself and provide your address, and the clerk will swear you in.
Can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God? Okay.
So I moved into this. Oh, we're excited. Standing here today, though, shows that it's on the property values on our block. As of right now, there are no fences along any of the yards. Plenty of backyard and side fences are great, any in the front. So as is aesthetically, wood, wrought iron, picket fence. Stay consistent, the arc or wood, what exists. And of course, in regards to paint, the product, galvanized steel link fence. I don't think that argument is because a cedar home, cross cedar siding.
Before you leave the podium, does the board have any questions for this individual? No? Okay.
yeah,
Oh, go ahead.
you said that you guys just moved in when?
10 months.
10 months ago? Was there any chain link fence there? Okay, that's all.
Thank you
And
for your
Mr.
statement.
Wolf, is your last name common spelling or E at the end?
Spelled W-O.
Thank you.
Thank you. I believe our representative, the applicant, would like to provide an additional statement. Okay, you can come up.
I moved into 4044.
Make sure we speak into the microphone, please.
I moved into 4044 Ben's house in 49 years ago. And there were two fences. Chain link fence at 4040 and a wooden fence, a 44 fences side by side. I took the fence down, left the chain, I was perfectly happy. Came within 12 inches of the sidewalk, as I recall. I don't have any error to prove that, but that's my memory. The subsequently, the Jacobs decided to remove their fence off. For about grandfathering, you have to do some research about when the code was changed. A lot of grandfathering get involved. But I think the question of aesthetics is subjective. As I say, I think significant. alternative is not going to be any less impressive and actually be more visible, more of a vision. Comes to debating over inches can get very much more complicated. So I hope the board will find it possible to approve the inner 4-inch variation and the material. On to the question of the 29-inch intrusion into the right of way.
Does the board have questions at this time? Hearing none. Thank you. You can sit down. Yes, Inspector Burr.
So just as a matter of clarification with respect to potentially having to amend the fence, the code again specifically says that chain link fences are prohibited in front yards, but they are allowed in side and rear yards. So if a modification has to be made to the fence, page 3 of the packet is the proposal that was provided from the fence company. And if you see, as they have the house marked there, if you draw a horizontal line across the face of the house, that is where the front yard is. So it isn't that the fence along the entire length of the driveway would have to be removed, but it is from the front of the house forward towards the sidewalk in the front yard. Once we get to the front corner of the house, that becomes side yard, and the chain link may remain in that location back
At what height for the side yard?
4 feet.
Okay, so regardless of whether we're talking about the front or the side yard, the maximum height is still 4 feet?
Correct.
Okay. Any questions for Inspector Burris on any of those points? Okay. Do we have any individuals in the audience that would like to make a statement? Okay, please come to the podium, say your name and your address, and the clerk will.
Crawford, 03, Farwell.
Crawford.
Mr. Crawford, do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Can I ask Inspector a question? Contractor?
It was the homeowner of 4040 North Farwell, Renee Jacob.
The reason why I ask is Ross placed them. You did not catch it. I think that's incredibly unfair. I don't think that it's ignorant. I also believe that ignorance of the law is not anything. So I don't support the appeal to the order. I've been neighbor for 15 years. Without getting into too much history, the neighbor has documented issues with the contractor. I don't know if you've seen it here, property. There's an orange traffic that replaced garbage parkway for months, which is illegal. I believe the neighbor pattern. I don't believe they're ignorant. Oh, because they had a chicken. They know it. So for that, I'm a front porch. Wife and I sit on my front. Now look at it. Traffic. By the way, a traffic free for marking off an area for children or a dangerous area. And it's whatever this right of way is, it's on the sidewalk, right abutted. So this is what we look at. Now, the taxpayer, again, I'm worried about home value. Need to stare up, look at a fence that's not variance, that frankly is lowering the value of the property. If I did that, it was a mistake. There's an order of correction that I do believe there's another neighbor that also.
Does the board have questions for Mr. Crawford at this time? Okay. Thank you for your statement. This may be a good opportunity to reference the 3 emails received to the village clerk regarding this matter. Toya, can you briefly describe those? You don't need to read them out, but we'd like to introduce them into the record so that we can
Sure.
consider them.
The 2 emails were actually sent by the same person, Therese Pilarzi, at 4028 North Farwell Avenue. Ms. Pilarzi does not support the chain link fence, and she is in agreement to restricting the chain link fence in the front yards. And she also quoted the village code 225-8 parent 7. I have another email that is from Jane Shiro at 4048 North Farwell. And she is also writing, respective to that, she stated her concerns for the chain link fence being constructed. Now, did you want me to read the bullet points? Because she does have bullet points. And I will say, let me just say that she reiterated Mr. Crawford's points.
I don't think it's necessary to go through the
Okay.
bullet points.
And that is all.
Can I confirm with the board that each of us has received those emails from the clerk earlier today?
Yes.
Okay, good. Okay. Unless there are any other statements that would like to be given by individuals in audience, I believe we can proceed to discussion, although Mr. Ford, do you have another statement that you'd like to give? Do you have another statement you'd like to give? I believe that this is maybe your last opportunity to provide a statement on record before we go into discussion.
Had hoped not to get to this point. When it comes to question of inches, which is one of the 2 issues to deal with. You should be aware that it's next door at 4036. There's a construction underman, almost finished, that because of an error in the drafting that appears to be 3 feet from the side property line is in fact only 30 inches. The house is not parallel to the plot line. Front of the house is about 40 inches from the lot line. The back of the house is 36 inches. The 10-foot extension comes to 30 inches from the property. Mrs. Jacobs is perfectly willing to overlook that 4 inch height of her fence. All of the other problems are because of neighbors' intrusion. The fence defensive mechanism, and I'm sorry you're getting involved in this. That's.
Thank you for your statement. Are there any other? Yes, you may respond. Please come up to the podium and please provide a brief statement so that we can proceed to discussion. Can you please provide a brief discussion or a statement so that we can proceed to discussion on this matter?
Statement I want to say is my house is almost 100 years old, 98 years old. And it's true that there's only 30 inches between my house and her driveway. But I'm assuming that they knew what they were doing back then, gave a variance. But 100 years later, to say that, it can't be like that, there's no way of it. In terms of, yes, we did have some construction done, but hassle all of my work. Actually, her back fence is on my property, but I don't want to get into that with her. I never called her on that. So all this stuff about, it's just, but yes, 30 inches. And the problem is that it makes it very difficult for me to maintain my home with only 30 inches. because she will not let anyone step on the driveway. That's why she's got the cone out. Because somebody might want to step on the driveway. She's got the railroad tie on either side of her house. And next to me, to him. Because she doesn't want anybody to step on her property. I've had guys come and cut my lawn. He's called the police because when they get to the end, turn around. I'm stepping on. I mean, it's just that she has to protect her. I have no reason to go to her property. I choose not to go to her property. But yes, there may have been times when I stepped on her property, but I'll tell you, they never did it twice because she started screaming that she's calling the police. I mean, last week, I had some concrete put in my backyard. And when they do that, they smooth it out with this pole that's probably 12 feet long. Okay, so he's doing this, pulls it back, goes over the fence onto her above her property, doesn't touch anything of hers or whatever, but in the air above her property. So for her to pretend that she has to do this to protect herself.
Thank you for that additional statement. I believe we're getting into discussion that is not necessary for the board to consider this. So at this point, I'd like to close individual statements and proceed to discussion of the matter by the board. Okay. All righty. So I believe we have a number of preliminary issues here, and I'd like to propose whether the board is in agreement that the issue regarding the request or the encroachment into the right of way is not under proper jurisdiction of the Board of Appeals and should be resolved by the Board of Trustees. Is there any discussion or comment on that by the board, or are we all in agreement on that point?
Yeah, I'd agree with that.
Okay.
I agree.
That sounds like a unanimous agreement that for matters relating to that encroachment into the right of way, that should be directed to the Board of Trustees. Our second point, I believe, is whether this request for variance is actually a request for a use variance, in which case is the board prohibited from considering or granting a use variance, or whether we would like to deem it not to be use variance and consider as a normal variance request. Is there discussion by the board?
You mean
On
the
that
use of
point.
a chain link? Right, right.
The ability of the Board of Appeals to even grant a variance
Under-
for a chain link fence, or
Right.
whether that is prohibited as a use variance?
Okay.
Mike, do you have a comment?
I agree with Attorney Bayer that this is a very close question and I could see going either way, but it seems to me the more reasonable approach would to treat this as not as a use variance, but simply as a question of the type of material on an otherwise permitted fence. And that therefore that we could potentially, or that we have jurisdiction to grant a variance pursuant to the code. So I would proceed with the discussion of whether or not a variance to build a chain link fence in a front yard should be granted in this particular case.
I tend to agree, given that Attorney Bayer can't give us any definitive guidance from Wisconsin authorities telling us that this is specifically a use variance. And without that kind of guidance, I think it would be appropriate for us to acknowledge jurisdiction to hear the request for a variance and proceed from there.
Yeah.
It sounds like we have unanimous. Do we have to take that to, no, we don't have to take that to a vote, right?
Mm.
We're in agreement that we will, for this matter, we will not consider this to be a request for a use variance. Therefore, we will proceed with consideration of the request as just a standard variance under the normal standard of review that Attorney Baird has explained to us. At this point, I'd like to open it up for discussion amongst board members. And specifically, it sounds like we're talking about two different items here. One is the material, the chain link, which is prohibited in a front yard under the code. Two is the fact that the overall height of the fence exceeds 4 feet, which is the requirement under the code. Mike?
I'll jump in. First, with respect to the height, we as a board, as recently as within the last year, have denied variances from landowners who built a fence that exceeded the height, arguably in error during the course of construction, but was a matter of a few inches too high throughout the perimeter of a property. So that clearly that is something that we can address, and something that we have in the past, as a matter of precedent, have denied. And I find that if we were to look at the standards of review for the granting of a variance with respect to height, there is nothing here that indicates, there's nothing in the record to me that indicates there's a practical difficulty or unnecessary hardship in, regardless of the material, building a 4-foot fence versus a 4-inch fence. So none of the standards by which we have in the past granted a variance with respect to height, or granted a variance on any matter, would seem to apply with respect to the height variance. So that, to me, there is no basis in the record for granting a variance with respect to height. With respect to the material, I think we have the same situation, in that there's no indication of special circumstances. Sorry, I got distracted by something. There's nothing in the record which indicates there's anything unique or special circumstances or any potential hardship related to the type of material that would be imposed or that would be used to construct an otherwise permissible fence. So that if a fence, so that there is, and furthermore, if we were to grant a variance with respect to chain link material on this particular property, we would end up having no basis as a matter of precedent for denying a chain link variance for any other property in the village, since there is nothing unique or unusual with respect to this property that imposes a hardship that requires the use of chain link. So in my mind, on either of the two matters, there is no basis within the village code for granting a variance.
I agree with all of Mike's statements. And in addition, in our standard, we're looking at whether granting a variance would be contrary to public interest. And here we have multiple statements from neighboring properties that have expressed not to support the request for a variance here, and no statements from other neighboring properties that do support a request for a variance. Are there any other comments that board members would like to make at this time?
Sorry, I didn't hear anything telling from the appellant indicating that there were special that would lend to having a fence that is 4 inches over. In the other situations that Mike described, where we had denied variance based on height, there were somewhat compelling arguments to grant the variance. Here.
As to the height issue, I think if we look to the contract with Milwaukee Fence, they certainly were aware of the 4-foot height requirement.
Mm-hmm.
So
Yeah, the best testimony we have is that there was an oopsie moment of, there was already a 4-foot board and they didn't take in the measurement, which doesn't make sense to me, really. And we've never granted a variance on that. Yeah. And a laser.
Any other comments at this time? Okay, are we ready to proceed to a motion to vote on this request for variance?
Should we do it as two separate motions, one for height and one for chain link, just so that the record is very clear?
Yes, we can do that. Would you like to propose a motion, Mike?
Yes, I will. I move that the request for a variance of Village Code 225-8B(7) to place a 4-foot 4-inch fence in the front yard at residential property 4040 North Farwell Avenue be denied.
I'll second the motion.
To clarify, it should, we can double check on that, but I believe that we want to clarify that we're in the front and side yard, that it cannot exceed 4 feet. Not just the front. Is that's correct?
Yeah.
Fair statement.
Yes.
So that the modification would just be place a 4-foot fence in the front and side yard et cetera. So I guess it's just adding and side yard to what I previously stated.
And this is 225-8B2. As to the 4 feet.
Good catch, yes.
That is correct.
Okay, so to clarify that, this is the request for variance. Village Code 225-8B2. To request to build a fence in the front and side yard exceeding 4 feet be denied. Do I have a second for that motion?
I'll second.
Kara, second. And I believe we can proceed to a vote. And this is the first of 2 votes. This is just on the height of the fence.
Okay. All right, Cara Espera. Michael Polson,
Aye.
John Tutenhoft,
Aye.
David Keating, Wendy Smith.
Aye.
Motion carried 5-0.
Clarify that was a motion to deny the request.
Yes.
Okay, proceeding with the motion for building of a fence in chain link in the front yard.
I'll try to get it correct on the first draft this time. I move that the request for a variance of Village Code 225-8B(7) to place a chain link fence in the front yard at residential property 4040 North Farwell Avenue be denied.
Can we proceed to a vote?
Yes.
Wanted to give you a second to
Thank
finish your
you.
writing.
David Keating, Wendy Smith,
Aye.
excuse me, John Tutenhoft,
Aye.
Michael Polson,
Aye.
Cara Espera.
Aye.
Motion carried 5-0.
Thank you. So in some requests for variance as to height and to building material have been denied by the board tonight. Any other, any other statement or commentary from the board? If not, I propose that we call this meeting to an end.
So move.
Second.
And can we call a vote?
All in favor?
All those in favor of closing this meeting, say aye.
I
Anyone opposed? Okay, have a good night. Thank you.
Thank you.